Hi, this is Meet the Professors. I'm Dina Pollard-Sachs, and I'm on location at the UC Irvine School of Law with Fred Galvis. We're talking about sex torts, and this episode is Sex Torts 2, The Cases. So first, let's kind of recap on what are core transmitters in case people didn't see Sex Torts 1, the last show. And what's a core transmitter?
Yeah, those core transmitters. You know, I thought it was so interesting when you read the statistic about 3% are the people that are responsible for about 100% of the problem. So let's do some examples. Who are these core transmitters? Or
well, let me back up. The statistic that about 3% were responsible for 100% of disease transmission, that was from the early 2000s, and that has been questioned. And especially today with young people having more partners than ever in the past, that probably is no longer the case. It probably is a larger percentage, but here's what we know. There's never been a lot of people who have more than 5 partners a year. That's always been a small percentage of Americans. So I would say it's probably still less than 10%. And the reason why is because people who have more than 5 sexual partners a year are much more likely to contract the disease and then to pass it on. So core transmitters are these people who pass diseases on over and over and over again. If we could stop them from transmitting sexual disease, theoretically, all sexual disease would die out within 1 generation because sexual diseases need new bodies to stay in circulation.
And what percentage of those core transmitters realize that they are core transmitters, and how many of them are just negligent? They don't understand. They're maybe engaging in negligent behavior, but they don't really understand that they're a transmitter.
That's really hard to say. I think, for example, with herpes, it's different than with human papillomavirus. So in all the cases I've either watched at trial or know about from talking to the attorney on the case, it's always been a man who knew he had it and just ran around and stuffed a lot of women and gave a lot of women this disease. Now, human papillomavirus is very different. People don't know they have it sometimes, although there was one case with a famous professional athlete where he really didn't know he had it, but the court said, yeah, but you sleep around a lot. Your lifestyle, you should have known you had. And they nailed him for battery under substantial certainty analysis, which he didn't actually know, so it was more like negligence. The court said, when you act the way you do and you're known, because this is a celebrity and this guy, people knew he got around, the court held him responsible. Well, he actually gave HIV too, which is a very serious disease. Let's talk about the cases that I watched one in Dallas last October, and then I know about other ones.
Was that the Bear v. Redmond case?
No, I didn't watch. That was actually in 2009, and that was one of the first of the new wave sex tort cases. And when I say new wave sex tort cases, I'm talking about the cases that have come out post-2000, based on sexual disease transmission. We talked about in the last show about how sex torts used to be about defiling a woman and her suing for seduction in the early 1900s for loss of virginity and loss of ability to find a husband. Now it's more about disease transmission, although there still are cases where people get sued for husband stealing and things like that. We'll get to that in a minute. But Bear versus Redmond was the first big seminal case. And what happened there was a lady around my age, 50s, something in her 50s, met a guy from Palm Springs, and he was something special. I mean, he had his own plane. He picked her up in a plane, and the whole whining and dining thing, and she was enamored. And he did not tell her he had herpes. And she was pretty upset when she found out. And so she sued him. And the California jury gave her $6.75 million for the herpes infection, which included a large amount for punitive damages because he had a lot of money. But the idea that he wouldn't just tell her or warn her, about that is pretty wrongful, I think, because this is a woman who's, when you're in your 50s, you don't have the same immune system as you had in your 20s. So she was really
she
damaged.
thought she was engaging in safe behavior to the extent that she was not. She didn't have many, many different partners. Although some people would say, regardless if you think you know someone or not, it's perhaps, they didn't hold it in this case, but would it be assumption of the risk if you ever have unprotected sex?
Well, see, that's the thing is that Sean Murphy, who was the attorney for the case out of California, went on an intentional theory. Because assumption of the risk is not a defense under intentional theory. If you're talking about fraud and battery, basically, a form of battery through sex, this is the way it works. Battery is the intentional, offensive, or harmful contact to another without their consent. Now, here's the deal. You consent to sex, but if later you found out the person had a disease, then the consent is invalidated after the fact because the idea is had you known about the disease, you wouldn't have consented in the first place. So that's the theory he goes for. And in that situation, assumption of the risk is not a defense. Assumption of the risk is a defense to negligence and strict liability, but not intentional torts.
Well, the idea, though, would be that if we want to modify behavior, clearly we have to have tort liability for the core transmitters, but it might be kind of a second line of defense if the victims of core transmitters also themselves say that they want to engage in safe sex. So
well, they did in the cases that I've seen. I mean, for example, the case that really instigated my research into sex torts and caused me to write the law review articles and now the book called Sex Torts, it's forthcoming, was a case of a lady who, again, was about my age, you know, very innocent, had been married for, oh goodness, I don't even know how many years, dozens of years, to the same man, the only man she'd ever had sex with. Got a divorce in her either late 40s or 50s, I can't remember, and the first guy she met, you know, seemed like a nice guy, a pilot, and he hung out at the local coffee shop in the town, and she met him, and they dated for 5 months, about once a week on average, had lots of long discussions, and they had the safe sex discussion, and he specifically said to her, I'm safe, I don't do flight attendants. And when I heard that later, I said, gee, didn't that strike you as, I mean, the kind of statement someone would make who is pretty immature? I don't do flight attendants, but see, she had one man her whole life. She didn't see it coming. So they were together one night, and you know, she woke up a few days later in excruciating pain, and you know, he didn't even call the next day or anything, which is kind of rude to begin with. And then when she finally called him a couple days later and said, you gave me herpes, his response was, I never got a phone call like this before. No apology, no admission, nothing. The worst thing is, she went back to that coffee shop, and there he was again, picking up other women. The very, you know, 2 weeks later. So that's a core transmitter. That is the definition of a core transmitter. But let's take the other case we were talking about outside of the show. This Jewish lady came to California at age 17 or 18 with her family, moved into LA, never dated. You don't date in her community. She was a very religious woman. You only get set up through your family members. A man approached her uncle and said, I want to meet, you know, your niece, and they ended up getting married. They were married 16 years, and after 16 years, he said he wanted a divorce. She was shocked. He moved out, suddenly moved back in, and almost immediately tried to get her to sign quitclaim deeds to all their properties, which is probably why he moved back in. But before she even got through the arguing with him about the quitclaims, she found herself with something wrong with her, and she was so innocent that she did not have any idea it was herpes. And when she found out, she was devastated. I mean, she wailed in the doctor's office, couldn't leave the doctor's office, finally got in her car, drove, and immediately crashed into the building. So, you know, why didn't she question her husband? Well, she had no idea. And by the way, in that case, it turned out that he was on all these hookup websites and Craigslist, and he is probably a core transmitter because of all the women he had been with behind his wife's back.
Well, certainly for the core transmitter, there should be the tort liability, especially when there's lying. Someone is relying on you to say, hey, are you safe? And you lie and say yes, and they're really not. That's, you know, inexcusable. But one of the points I was thinking about, though, is, and I know it smacks of blaming the victim, but because these women are victims, but should the message of this maybe be, don't trust people even if they tell you that, and still demand to wear a condom? Or is it okay to rely when a person tells you this? Because if it's a core transmitter, then they're probably going to lie.
The courts have been all over the place with this. Now, some places like California says it's a one-way duty. It's a duty of the diseased person to tell the non-diseased person. That makes sense to me, and that's why I advocate strict liability. Because I don't want to hear about, well, how long had they known each other? Had a duty arisen to tell the partner, hey, I have a disease? Because some courts will say if it's a one-night stand, what do you expect? I mean, you can't expect a lot of honesty and trustworthiness when you met someone an hour ago, versus a marital situation in which you should be able to expect fidelity. But a court in Washington said there's no duty to disclose an extramarital affair, Washington State, if you're married. Which seems just ironic, but the courts are all over the place on this issue.
And it seems like the duty should be more than just to disclose, but a duty to abstain if you're active, or to not have the kind of sex that puts someone in danger, even if for some reason they were to consent to it.
Right. Well, back to your question, I mean, what can you do? Well, one is know your partner, but also know they may not know they have something. So it's not just a matter of, well, I've known him 6 months, he's really honest, I've seen him in lots of situations. He may not know he has something. So it's not just getting to know your partner, but getting tested, because no matter how much they may think they know, they may not know. And the third thing is just consistently using condoms. These germs that are out there, these sexual diseases, are becoming so sophisticated and sneaky, they mutate. And some of them don't show up on tests, and some of them don't show up, don't manifest in your body for 10 or 20 years or longer. Then they manifest in the form of cancer, penile cancer, cervical cancer, all kinds of cancer.
What is a reasonable amount of time to test? In other words, when does it become negligent?
Every time you have a new
test?
partner. Every time you have a new partner. Because you can't know until you test. So every new partner you should test it after, but then there's lag time. It's very, very difficult. And this is why the disease rate is so prolific. Certain things don't necessarily show up right away. Other things should show up right away. Tests can be incorrect. There can be, false test results. So I think that testing should be done consistently. Only a third of doctors recommend STD testing for their patients, which is insane considering the sexual disease rate.
Why is that? Why isn't every doctor saying that you need to be tested? There's a duty of disclosure.
I don't think they know. When I spoke to a man who had 3 doctorate degrees, an MD, a PhD, and a JD, and he was a professor of law at the same time, and because I knew he had the medical doctorate degree, I said to him, did you know about this disease rate? And he said, where'd you get those numbers? Like, he didn't think it was true. And I said, the Centers for Disease Control. So he was shocked by the numbers. Now, he's not a practitioner, but he is a doctor, and he does work in health sciences. So I think that the government has just failed to tell the public how dangerous it is out there in terms of sexual disease, and that's why the rate has gone so crazy and out of control. But let's get off the sexual disease cases for a minute. Let's talk about the broken heart cases, because at the turn of the century there were all these cases for seduction, for ruining someone's virtue or whatnot, which now we kind of laugh at. However, a lot of people are surprised to learn that there still are cases out there where someone has deceived someone in a relationship. They have not gotten physically injured. They did not get a sexual disease, but they're out there. There's a number of states who still have, for example, alienation of affections. And alienation of affections is a cause of action that has largely been dismantled, but not, lots, Alabama, Alaska, Arizona, all still have this cause of action. Arkansas, California, Colorado, Connecticut, District of Columbia, Delaware. I have a chart in my book giving forth all the causes of action, all the states that still recognize them.
Do they still enforce that, though? Or
they do if they get the chance. Look at the case out of 1999 from North Carolina. Dorothy Hodelmeyer found out. This is what happened. This case is actually really interesting, and a movie was made out of it. The movie's called The Price of a Broken Heart. What happened was this man got a huge promotion at work, and his salary doubled or something. And all of a sudden, his secretary of 6 or 8 years, who always came to work frumpy and kind of dowdy dressed or whatever, all of a sudden she separated from her husband and started coming to work in short skirts, put on makeup. Her hair was different, and really made a play for this guy. Everything from, putting her leg over the chair and talking, and she's taking notes, and he's kind of he's noticing, okay, because everything's different with her. Over the course of a few months, she got him. And he had 2 or 3, I think 3 little boys at home, or he had children for sure. And she had no concern about his life, his family, his wife. And the coworkers really hurt her at trial. The things they said, the way she treated him in the workplace, she went after him. It wasn't just a matter of, things happen. Like he tried to say, well, I just fell in love. Okay, well, it was a plan. It appeared to be a plan. So what happened was the wife sued, and the jury gave her $1 million. That was 1999 out of North Carolina. And as I said, that's still available in North Carolina. Another case out of Georgia in 2013 called Kelly versus Cooper. And here what happened was this couple were kind of together for many years. They had at least 1 child together. I think they had 2 children together. And then he promised to marry her, gave her a ring and all that. And then she caught him cheating. They got back together. Probably not a good idea for her. Anyway, she caught him cheating again, and then he left her this time and left her with children, no money. And she sued for breach of marriage promise. And this is just a couple years ago. Jury gave her $50,000 to get back on her feet and all that.
What would you say of people that would say, hey, these are from a bygone era, and it's in a private realm. And although this is bad behavior, we should leave it up to individuals' private decisions. If they want to divorce a person, they can. If they,
Well, she was never married. She couldn't divorce him. She didn't have that remedy. But my response would be, you know, you can sue someone over a $50 gadget not working. You have consumer laws. You can get treble damages, attorney's fees over a $50 product that disappoints you if they lie to you about it, if there's fraud involved. So my concern is, why wouldn't the law respond to interpersonal fraud? Why would people in sexual relationships be thrown out of court when they get a lifelong disease or even just serious psychological damage? Because some of the people I've talked to, even those who have gotten diseases, say the hardest thing is they can't trust anyone now. They're afraid they're never going to have another relationship.
well, the law,
So the injury is serious. It's not just a joke. It can really hurt people.
the law is no stranger to regulating in this area. For instance, in evidence law, the area I teach, 412, in sexual assault cases, the rules of the defendant's and the victim's character are sort of turned upside down, where the legislature has recognized in sexual assault cases, we're not going to allow defendants to go after the character of the victim, where in other cases you can always go after the character of the victim. Or you can't open the door on a defendant's character in any other case, but in a sexual assault case, you can go after their character and bring up former sexual assaults. So the law recognizes this, the legislatures recognize
There's
this
nothing
special
new
area.
in this law. In terms of the disease transmitting crabs in an early Texas case, for example, so negligent transmission of diseases has always been actionable. There's nothing different here, it's just sex is involved. And in terms of, you know, not transmitting a disease, another case out of Idaho, where a husband and wife separated, as I recall. He had an affair, came back, didn't tell her about the affair, didn't give her a disease, but when she found out, she said, I'm disgusted, I'm offended. I would never have said yes to my husband had I known he had an affair behind my back. And the court said, she's got a point. Fraud vitiates consent. He committed a battery. Even though she didn't know till after the fact, it didn't matter, because straight up battery analysis says if you consent to something at the time but you did not know all the critical facts, that consent is invalidated when you do find out the facts. So there's nothing unusual about this area of law. It's just that it's a lot of courts don't find it palatable. They don't want to deal with sexual cases, but the reality is, because of what's happening in our culture and society and because of the level of sexual disease, it's happening and it's going to continue to happen. When I watched the case in October of 2015 in Dallas, there were 9 other herpes cases pending in Dallas at that time, and ironically, 8 of them were also doctors, like the defendant in the case I was watching.
You know, one of the things because you're one of the leading experts in the nation in this area, and you've coined these terms and the sex torts, but one of the things that you suggest in one of your law review articles is to move away from a negligence model in tort and have a strict liability for these kind of sexually transmitted disease, and maybe talk about why you think that would be helpful from a policy point of view.
Well, the negligence cases are so embarrassing for the plaintiff. They want to know how long did you know him, whether there was a duty at all, and the parties and the courts get mired in, should you have known, should you have asked more questions. We're talking about someone giving someone else a sexual disease, and particularly if they knew about it or if they should have known about it, they should be the person to disclose, because the person who doesn't have a disease and who doesn't know about it, they're just not in the best position to know, and the person in the best position to know, the cheapest cost avoider is the person with the disease.
Yeah.
And so to me, I'd like to take all of the analysis out of, well, how long did you know him, and did you guys have the conversation, did you establish monogamy, and just say, you know what, when one person gives another person a sexual disease, they should pay for it.
Well, the strict liability idea too, it's like with hazardous materials or very dangerous kind of activities. Instead of having the negligence aspect, you just say, look, when you're engaged in that kind of activity, then if anything bad happens, you have to pay for it.
Well, it also takes out the I didn't know I had it defense. The most common defense in negligence cases, well, I didn't know I had it, how could I have a duty to her? And here you have the core transmitters again, and they know they have it, but they're going to say they didn't know, and they're going to get off the hook. My analysis would take all that out of the equation and say, if you prove that this person gave you disease, it's strict liability, so guess what? That gives an incentive to get tested, whereas negligence creates a disincentive to get tested because the I didn't know I had it defense is no longer available.
Yeah. Well, and again, we often hear how ignorance is not an excuse of the law. I didn't know that there was a red light. I ran the red light. I didn't know that. Too bad. You know, ignorance of the law is no excuse, and maybe people will be much more careful, or at least assume the duty to make sure that they do the testing and engage in
Well,
the.
we need to stop the bleeding. We're talking about the most sexually diseased, industrialized country in the world, the most sexually diseased young people in probably the history of the world. Teenagers, young people are disproportionately affected. African Americans are disproportionately affected. This needs to come to light, and one of the ways it can come to light is through sex tort cases. You've been watching Meet the Professors. We've been talking about sex tort cases today. Please subscribe to my YouTube channel to watch more shows on sex torts, culture, and law.